versus Isaiah S. Curvin, and the defendant Isaiah Curvin appears in person and pro se. This is the pretrial hearing. The trial is set for jury Wednesday and Thursday of this week, February 7 and 8. There is one count of operating a motor vehicle without a valid license. Now, that seems to the court to be you either had a license or you didn't. Of course, the burden would be on the state to show there was no license, but Mr. Curvin, are you challenging that? Are you saying you did have a valid license?
No, I had a question before all that about the jurisdiction. I was challenging jurisdiction, so I had a question about that.
Okay.
I wanted to know the cause and nature of what's bringing the suit against you. So I really did.
Well, the people of Kansas, as you probably know, get together ever so often and have elections to elect people to represent them in Topeka, the state capital, and those legislators pass laws that are for the good of all of us in theory, maybe in practice, and then we are to follow those laws. One of the laws at some point in time that those legislators made was that if we are going to operate a motor vehicle in Kansas, we have to have a valid driver's license. And if you do not have a valid driver's license when driving the automobile, it is to be treated as a Class B non-person misdemeanor. And they set the penalties of up to 6 months in the county jail and a $1,000 fine. So the authority comes from the people of the state of Kansas
This is the moment the judge strips the mystery away. No secret tribunal, no hidden code, just Kansas statutes passed by elected reps. And look at the stakes. Up to 6 months in jail and a $1,000 fine for driving without a valid license. You can hear the judge trying to anchor the room in real law before this spins into YouTube law school. For Courtroom viewers, this is rule number 1. Charges, authority, penalty. Start there.
Didn't mean to cut you out.
Basically kind of more of a statutory violation. This defendant, when you enter into the state of Kansas, you consent to the laws of Kansas when you drive upon the highways. The interstate compact between all of the states that are members of the interstate compact for traffic infractions means that when you consent to the laws of your state, or you drive upon or travel upon the roads of Kansas, Oklahoma, any of the states that are part of the compact, you consent to those laws when you enter. So jurisdiction is set up, as the judge said, by the Constitution of the state of Kansas and the laws of the legislature that are passed statutorily, and our statutes are passed with the law in this case. I would note for the record, Judge, that there is still no things on Odyssey for me to see. There's not a written request for jury trial. There's no motions to be heard today. I cannot respond to any motions because there's none on file.
Well,
Therefore, if
he
is going to file anything of record for me to respond to, he would need to have his filings on at least 7 days advance of a hearing for me to respond, and that there is no proper written request for a jury trial at this. Therefore, this case could go to bench trial on Wednesday, and we would not have to have a jury present due to the fact that there is a lack of request for jury trial. And if there is no written request for jury trial, the case goes to bench.
The prosecutor brings it down to earth. When you use Kansas roads, you accept Kansas rules. That's the interstate compact in practice. Also key, paperwork. Courts run on filings. No written jury demand. No written motions. Then the state has nothing to answer. If you're pro-SE, this is the trap. You think the real fight is with the judge, but the real fight is the calendar, the statute, and the clerk's stamp.
Now,
what I'm understanding when you say the cause of nature, And but that's why I was not understanding still about that, because you said the causation. I had that, and I asked
Sir,
what I'm
if you
what am I
want
gonna.
me to entertain any of your arguments, you need to have them well thought out, and you need to have them
That's
in
what happened.
writing, and
That's
you
what the
need to
special
have them,
appearance is for.
sir, listen to me, please. You need to have them in writing. You need to have them filed with the court. You need to give copies and notice to Miss Gillette so she can have an opportunity to respond. And I'm not going to entertain this process throughout the proceedings where you come in and you just start
I have a question.
things
That's
that you
why
may have picked up here or there on the internet or by other people. I don't know where you get some of this stuff, but it is very common for people, certain individuals, to come in and start repeating some of this stuff that so far I haven't heard anything that has merit. These arguments of, well, you're either maritime or you're common law. That's not going to carry weight with me. You're going to have to give me something that tells me I have to follow those arguments, because I think you're misstating the law. So by now you should have had all your motions on file. We're ready.
Yeah, maybe misunderstood what I was
please
asking.
don't interrupt me.
I still had a question.
Sir, stop. If you want a jury trial, I will make sure you have a jury trial. If you want to represent, sir, stop interrupting me. If you want a jury trial, I will make sure you have a jury trial. If you want an attorney, I'll make sure you have an attorney to help you. But if you're going to do this on your own, you need to know what you're doing, and you need to follow the law just as an attorney would be expected to. But you're not going to come in here and just start saying things, and I'll answer questions as long as they're legitimate questions. So at this point, I'll ask you once again, are you sure you don't want an attorney to help you, someone who is trained in the law? Because this, sir, is a court of law, and if you don't have the benefit of knowing the law.
Well, before I move forward, I had questions before I move forward. That's why I was asking to understand it, because I was trying to understand this.
Well, I can't aid you in the unauthorized practice of law. I cannot.
No, I'm not asking. I'm not asking for legal advice. I'm asking for your legal intent. What am I going to? What do you intend to be trying me with jurisdiction? That's why I'm asking if it's under which one. And you said it's a criminal matter. If it's criminal, then there's someone's been hurt. So if there's someone's been hurt,
I have answered your question legally, and you keep trying to give me.
You can feel the judge's patience thinning. Have it in writing. Give the prosecutor notice. I'll give you a jury or a lawyer. Pick a lane. This is the hard truth. Courts aren't talk shows. If your argument is common law versus admiralty, you need a cite, not vibes. I'm not even mad at the defendant here. I'm worried for him. He's outgunned by process, not just by law.
Because of nature of the matter.
Sir, I'm going to find you in contempt if you keep talking over me and being disrespectful.
Ma'am, you keep not even answering my question before you let the jury try. You just setting it.
You are now found in contempt. We will deal with your consequences Wednesday at the jury trial. This is set for jury trial. It's going to cost the taxpayers some money, so you better make sure you're ready to go to jury trial come Wednesday. You better make sure you're not in Texas. You better make sure you're sitting in the courtroom in Greenwood County, Kansas. That's Eureka, Kansas. Do you understand, sir? Any questions about?
I still have questions that was never answered.
I'm not your attorney, sir. I'm your judge.
Yeah, I know you're not an attorney. I'm asking you, Judge. I'm asking for legal advice. I asked you what was your legal intent. You still haven't told me what you're going to ask you what was the nature and cause of this.
My legal intent is to conduct a jury trial on you Wednesday with the jury.
Here's the line that gets crossed. Talking over the judge after repeated warnings. Contempt. It's only $50, but symbolically it's heavy. The court is saying, we're done circling. If you're ever in this position, pause. Breathe. Let the record be clean. Nothing tanks your credibility faster than arguing while the judge is issuing an order.
The state has taken the opportunity to glance through the case Mr. Patterson cited. It can be distinguished from this case because the ruling says the person has to be subjected to up to 12 months imprisonment. It is a DUI case. where someone was convicted of a first-time DUI and they were subject to 12 months of prison time or jail time under the law. This is a Class B non-person misdemeanor that's 6 months or less. It must be greater than 6 months in order for the person to be subject to an automatic jury trial. Otherwise, lacking the request, it may be a trial to the bench under the case law. So therefore, the State v. Jones did not apply in this matter. He is facing no more than up to 6 months. So the automatic requirement for jury trial does not apply in this case to Mr. Curvin. The request for jury trial would still need to be in writing for a matter that's up to 6 months. And therefore, I would ask that we don't waste a jury's time and have a bench trial on Wednesday.
Big legal clarity. Automatic jury trials usually require exposure 6 months. This charge tops out at 6, so no automatic jury. That's why the written request matters. The state actually did the defense a favor by putting the standard on the record. Now we all know the threshold.
Move forward in the case.
Mr. Curvin, do you want a jury trial or a bench trial?
I want a jury trial.
Understand, I'm not going to prejudge, but Ms. Gillette, can I continue this for further pretrial hearing with the live hearing, defendant present tomorrow? What do you have? Can you fit me in at what, 2:30, Missy? Do you have time then? Pick me a time. Give me about a half an hour tomorrow that you can fit me in.
I think our 11 o'clock went off. Let me.
I was going to say 11 o'clock is the perfect time for the state judge.
Well, but I've got to give Mr. Curvin. I've got to give, sir, please quit interrupting. This is not a free-for-all. Miss Gillette, we've got to give him time to drive up from Texas. Well, if he doesn't have a license, he can't drive. We have to give him time to find someone who can drive him up here, or give him time for a plane ticket, or however he wants to get here.
1 o'clock p.m. from 1 to 1:30. Then we can start the first appearance docket at 1:30.
Sounds good. Okay. Sir, this is going to be a live pretrial hearing tomorrow at 1 p.m. You must be present.
I cannot make it tomorrow, ma'am.
Well,
you told me you said Wednesday at first, and now you're saying tomorrow.
Well, your jury trial is Wednesday. Your pretrial is continued to 1 p.m. tomorrow. There is no law that says I have to give you a Zoom hearing. I try to do that as a courtesy.
I could do the Zoom, but I wouldn't be able to drive because this where I'm at, I'm already right here by San Antonio. It's about a 14-hour drive. Even if I drove right now, I would still wouldn't make it to probably 2, and I would drive just 32, 14. That's half a day driving. Now I don't have nobody to drive like that. You know, man. That's why
if you don't have a license, you better not be driving, because then that'll be another violation of the law. But that's my order. Be here at 1 o'clock, live and in person. If you're not here, then
he asks for a jury. Finally, a concrete step. The judge responds with logistics. Live pretrial. Be here in person. Don't drive if you're unlicensed. This is the part many people underestimate. Courts can and do require in-person appearances, and distance isn't a legal shield.
Most likely a warrant would issue for your arrest, and we'd go from there.
Well, I'm telling you, if I wouldn't make it, what's my other option? If I'm already in Texas, not to. That's hours away. You know, it's about 4 different states.
Well, sir, you came to Kansas. You violated the laws allegedly in Kansas, and you've taken up a lot of the court and counsel's time. So,
well, I was told the officer said he told me I can take care of it from Texas. I will have to come back to Kansas when I got the rest of the ticket.
I have always told you that the trial would be live. Don't be pulling that on me.
No, not you. I'm talking to the officer when I got the ticket. When I first got it, I let him know I was just coming through Kansas. You don't live here. He said normally it's stupid do video and stuff because it's different state.
Normally it is, but I'm ordering that you be here in person tomorrow at 1 o'clock. And anything further, Mr.
Nothing at this time.
Hold on, my phone cut out. Hold on.
Mr. Curvin?
Say it again, ma'am?
Any motions you want to take up tomorrow at the pretrial, you better have them filed by 5 o'clock tonight with copies served on the prosecutor, or I'm not going to entertain them tomorrow. You've had a long time to get
Did
those
you
on
have you
file
received?
and you haven't done it. And I'm through with repeating myself over and over. So at this time, you owe the court $50 for contempt. We'll address that tomorrow as well. Okay, we'll begin recess.
When I have a
Thank you,
question
Judge.
before we go, when you said about to file the motions and everything, did you receive my special appearance motion or anything like that?
Nope. No, sir.
You hadn't received it from last time?
Nope.
I filed that before.
No, sir. I don't know what you're doing with them, but we're not getting them here.
I was told that you had received them through email, or I sent the email
Okay,
to I sent it
sir.
3 times. Not like that was the only way.
If you can't figure out how to do it on your own, then you need an attorney. And I have told you repeatedly that if you cannot afford an attorney, you can
No, they
appoint
told me.
one, and I will appoint one.
They told me they had received them before. That's why I was understanding. Like you say you never received them, but you say you received them before. Like the first time we appeared, and then
Final orders are crisp. Be here tomorrow at 1 p.m. File any motions by 5 p.m. today, or the court won't hear them. Another reminder, courts speak deadlines. Miss them, and the law doesn't chase you. You chase the consequences. Content note, no graphic content. Keep audio clean. If any overlapping crosstalk becomes chaotic, lightly duck the room audio under VO for clarity. No blur/bleep needed.